House Bill, second reading, regular. First up upon the recess is House Bill 1979, a bill to amend and reenact several sections of the Code of Virginia relating to assisted conception. The bill is before the Committee for Courts of Justice.
Delegate from Fairfax, Delegate Sullivan.
Thank you, Mr. Speaker. Mr. Speaker and ladies and gentlemen of the House, HB 1979 has come to be known as Jacob's Law. I guess at the moment it's Jacob's Bill, and I'm sort of hoping this body will see fit to help make it Jacob's Law. What it does is update Virginia's surrogacy statutes, which are now 25 years old and have had really no attention to them in those intervening 25 years. And among other things, they're even out of balance with changes we've made to Virginia's adoptions laws. Now, let me point out, I just said the law was passed 25 years ago in 1994. That means Virginia has had surrogacy law in place for a generation. Nothing about 1979 creates new law, blazes any new ground in terms of Virginia or this General Assembly's approval of surrogacy as a way of building a family. All 1979 does is update things, bring us into the 21st century, and take account of new technology over the last 25 years. In some members of the House, it updates the law. It does neutralize the language, gender neutralize the language in the bill. And we can get into the weeds if you like. Among other things, important things it does is it clarifies the distinction between a traditional surrogate and a gestational carrier. And it generally streamlines the process, making it easier for Virginians to avail themselves of surrogacy as a way of becoming parents. Mr. Speaker, this is a bill that promotes life. It promotes creation of families. I have to say, frankly, I was, I suppose, naively hopeful that I'd actually be on the same side of the Family Foundation on this bill. Now, I know there are some concerns out there. I'm happy to address some of them either under questioning or I'm going to try now. I want to assure everyone in the chamber, and more importantly, your constituents, that nothing in 1979 creates a new market for embryos. Nothing in 1979 is going to have people buying and selling embryos. In fact, it's already against the law in Virginia to broker embryos. Nothing in 1979 is going to create lab babies or anything like that. The bill that already exists, the language in our code that already exists, has lines and lines and lines of protections and oversight of how these things, these surrogacy contracts are done, supervised by courts with guardian ad litems appointed and appointment of counsel for the surrogate. There are a lot of protections. This is already a system in place where this assembly 25 years ago thought through how they wanted to allow this technology to go forward, but in a responsible way. The fact is, Mr. Speaker, that in the United States right now there are something on the order of 1 million frozen embryos. 1 million frozen embryos. The technology of surrogacy is getting better and better. And most people who have frozen embryos want to donate them to others. What happens when an embryo is frozen in a lab, it can be used by either the people who created the embryo or someone they might donate it to. The other option, of course, is that it be destroyed. Most people are looking for ways to donate their embryos. Mr. Speaker and members of the House, HB 1979 brings children into the world. Children who will never, ever, ever wonder, was I wanted? Because someone having a child during using surrogacy goes to great lengths, frankly great expense, to bring that child into the world. Now I want to address one issue that I know is out there. There's there's a discomfort with a few of the lines in the bill that use the word own or ownership. That's not my word. A term of art, and it's used fairly regularly. I'm reading from a decision out of the 10th Judicial Circuit of Virginia, Judge Kimberly White, Mecklenburg County Circuit Court, just about a year and a half ago, Mr. Speaker. This is, as the judge, cases are happening all around the country, a couple divorcing who had created some embryos because the wife had breast cancer and was going to become infertile as a result of her treatment. So they had some embryos frozen, and they were fighting, frankly, over what to do with the embryos. The husband wanted to have them destroyed. The mother wanted to use them. She actually wanted to have a child. And reading from the opinion of Judge White, she talked about how the issue is which party should have the fertilized embryos, which were marital property. That's how the court has to, in these situations, deal with these situations. The contract that the people who created the embryo signed with the clinic talks about how embryos are understood to be your property with rights of survivorship. And the court, as it reached its decision, which, by the way, was to award the embryo to Mrs. Patel so she could try to have a baby, applied Section 20-107.3 of the Code, which has to do with the division of marital property. So, Mr. Speaker, I get it. It sort of hurts. It hurts your ears. It hurts your eyes when you see the word own or ownership associated with this bill. But it is how the law treats these things. This sort of very high technology way of doing things in today's world. You know, Mr. Speaker, it was less than a week ago. Candidly, it seems a lot longer than that, but it was less than a week ago when you gave a very moving speech here on the floor, and you introduced us all to, I think her name was Monique, who you pointed out wouldn't be here but for a very fateful decision made by her mother. Many of you here today, I know the committee last week, many of you here today have met Jacob, for whom this bill is named, and his sisters, CJ and Ellie. I think actually they may be in the gallery today. Together with their parents, these 5 people form a wonderful family, a fabulous family, an all-American family. Jacob's story, which was the inspiration for my bringing this bill, is a long one. Some of you may have gotten some emails about it. The legal obstacles that were put in the way here in Virginia to Jacob being, I'm telling you, these are hard sentences to get used to Jacob being thawed and placed in a surrogate. The legal obstacles were enormous, and his parents had to leave the state and were embroiled in a terribly long legal controversy. But Jacob and his sisters would not be here today among us, would not have the futures that they each have, were it not for 2 loving parents who desperately wanted to have a family. The dedication of Jay Timmons and Rick Olson to go to the time, expense, the depth of their love of family, to me is inspiring. They had a friend approach them, who, I guess it was a couple approached them, who had embryos that were frozen. I think the woman was no longer of childbearing age, and they came to Rick and Jay and said, would you like one of these embryos. Jay and Rick, who already had 2 beautiful daughters, said, of course, we would love to expand our family. And they took the necessary legal steps and necessary medical steps to take an embryo which had been frozen for 13 years and turn it into Jacob. You have sitting in the gallery a beautiful all-American family, and all HB 1979 does is allow more Virginian families to follow the lead of Jay and Rick, to allow more Virginians to access this technology that allows people who otherwise cannot have children to have children, to bring life to embryos that have been frozen. So I hope, Mr. Speaker, that we can get past some of the misinformation that's out there, and that we can get past some of the new language and new way of thinking of things, because this, of course, is not the traditional way that most of us here created our families. But it is an increasingly important way for many Virginians to have families. So I hope, Mr. Speaker, that we can get past some of the misinformation out there, that we can focus on what this bill really is, which is about promoting life. And I hope it'll be the pleasure of this body to engross this bill and pass it on to its 3rd reading.